All right, so for this morning we're going to be talking about conduct issues, and then we're also going to be discussing the idea of drug policies related to the Fourth Amendment of the right to privacy. But first we'll talk about conduct issues first. Conduct issues are relegated primarily by the governing bodies such as school boards and things like that. They typically are presented in the form of issues related to drug and alcohol abuse or usage, prohibitions against marriage in the high school settings, or general rules about conduct or speech. These rules are presented by most states, again, through the school boards. And like a reminder, again, the courts have deemed as sports as a privilege, not necessarily a right. Therefore, a lot of these rulings or these rules that are put forth by schools are to create an environment in which people can not disrupt the ongoing social background and network of the school. And in other words, schools want to maintain order. So they create rules like these to try to maintain order, and if through sports that order is disrupted, oftentimes the legitimacy of trying to maintain order in the educational environment usurps or trumps the constitutional privileges such as maybe free speech or freedom of expression, those types of things, for the greater purpose of the government's purpose of education. Anyway, the standards of valid conduct rules, when no constitutional challenge is brought against the rule, there are two criteria for determining whether the rule is valid. One, the rule can't be arbitrary or capricious or unreasonable, and the rule must directly affect the operations of the school. All right? For the three standards in which oftentimes challenges occur are because of maybe due process, someone's due process, usually procedural due process, has been violated. They haven't been able to defend themselves as a result of maybe a breaking of one of the rules. Equal protection clause, meaning having people having equal, there's no racism or privilege being given to one group of class person, and also then the First Amendment of the freedom of speech and or religion. Okay, moving on, we're going to talk a little bit about drug testing. This is going to be perhaps helpful as you start looking at the two cases that have been assigned for this segment, the Acton versus the Vernonia School District versus Acton, and the University of Colorado versus Dearden. But again, in 1989, the United States Supreme Court held that the state-compelled collection and testing of urine constitutes a search, and therefore is subject to the demands set forth in the Fourth Amendment. Again, for a search to be conducted of one's private life, there has to be probable cause is usually the primary trigger that requires that. So there, on a rule basis for a school, there tends to have to be some kind of substantial need for a drug test to be taken in order to fulfill the governmental purpose, and that purpose has to be compelling. All right. The Fourth Amendment, as a reminder, states the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue upon probable cause supported by an oath, affirmation, or particular describing the place to be searched and persons or things to be seized. Part of the reason why the Supreme Court in 1989 ruled that a urinalysis was a search was that all of the many aspects about one's life that can be discovered through a urinalysis. You can find out a lot about a person through that type of test. That goes beyond the scope of just the drug test itself. So, to determine whether a drug test is reasonable, the court basically balances the intrusion of the test against the interests of the legitimate governmental interests. So again, we've talked a little bit about this before. So for example, you can get searched in an airport through a scanner or a body scanner that's quite invasive, in part because we're trying to make sure that nobody gets on a plane that's going to have a bomb or hurt a bunch of people. You can be told to stay home because of the governmental interest, because we don't want to get people to be sick. Although, even though, it seems like that there are some liberties that are being taken away for that matter. You can't scream fire in a movie house or bomb in a movie house anymore without going to jail, even though that seems contrary to your right to the freedom of speech, because not all speech is necessarily free. There is some speech that is detrimental to society as a whole. And likewise here, searches have to be reasonable, and they have to be warranted. So, as an example, if you're driving down the street and a police officer pulls you over, they have to have a legitimate reason why they're pulling you over. And if they ask to search your car, again, they have to have probable cause to be searching your car. Now, there are some interesting rules that are on the books, at least in the state of Illinois, for example, that you could be pulled over for hanging an air freshener from your rear view window mirror, and somebody could legitimately pull you over, a police officer could pull you over for just having that kind of item in your car, because they would see it as an obstruction of your vision and block your vision, and therefore pull you over. A police officer cannot search your car unless they have probable cause. So if they see drug paraphernalia in your back seat when they pull you over, they have probable cause immediately and they can search your car. But if they don't see anything, they can't have probable cause. They might ask you, can we search your car? And if you say yes, then they can legitimately search your car. But they would have to have probable cause in order to search your car. Same thing with your house, for that matter. And likewise, oftentimes when it comes to drug testing, schools or institutions institute a drug testing program, they'll often have a waiver in which you have to sign in order to be able to have that drug test. Again, you're giving them permission to do that. If you don't give them permission to do that, they may stay or stipulate, well, then you can't play in the sport. It is a privilege, and if you don't want to be drug tested, you don't have to play in the sport. So that's how they balance that out. However, if there is a liberty interest or a property interest, say maybe you need to play in the sport because it's going to create opportunities for you to garner scholarships and whatnot, and so on and so forth, and you could prove to a court that those opportunities are being lost as a result of you not being able to be able to participate because of this new rule, you might have a challenge available. However, if the school has a real problem going on in their school that institutes a comprehensive drug testing policy because it's trying to curb or handle a problem that's present in the school, that might be the compelling governmental interest necessary for that school to be able to do that policy, regardless of whether your Fourth Amendment rights are going to be intruded upon. Okay? So, in conducting the balancing test, the courts examine the following three factors: the legitimate privacy expectation, the character of the intrusion, how invasive is this intrusion going to be, what are they going to be testing for example, in a drug testing policy, is it just a particular drug or a variety of other things, and also who's doing the testing. Could also, procedurally, due process is really important as well. Is it someone that can, by just one verbal conversation with somebody, could automatically make you look bad as a result and invade your privacy by sharing with others? Or is it more maybe an external organization that's doing the testing that doesn't know anybody at your school, and so on and so forth? Those are all real life factors. And the nature and immediacy of the governmental concern. Is there a problem that the government is trying to curb? All right. Okay, I've kind of gone through some of these. I'm going to scooch through some of these fairly quickly. So in determining the character of the intrusion, the court examines both how the drug tests collect samples and the type of information being collected, and really how that information is being disseminated as well. All right? Another aspect about drug tests is especially if the randomizing of drug tests, because you can't have a drug test that's specific to a general group. You can't say, we're going to just drug test just the girls, we're going to just drug test just the boys, we're going to drug test just the black kids in the class, or the Asian kids in the class. You can't do that. You can't do that kind of drug testing because it would be very arbitrary. So oftentimes drug testing is done in a randomized way, and even then it can be very particular. How do you satisfy random? Is it truly random, or can somebody in the through the procedure of doing the drug test, could somebody claim that you're being arbitrary by just picking people, certain specific people, to be drug tested, as opposed to the whole group on a random level? All right. All right. Fourth Amendment requires that any search can be conducted, there must be probable cause. The Supreme Court has waived the probable cause requirement when the state has shown a special need. So, again, if the school, remember, a state actor can be a school, and if they feel and they can prove a special need, that probable cause concept can be waived. This happens sometimes when school boards are a function of the state as well, because they are the decision makers of schools. So at the school level, so if a school board votes unanimously for some kind of drug testing policy to begin as a result of some problem going on at the school, they may have standing in order to do that. And then, like I said, normally when there are drug testing policies that take form, a consent waiver is issued and given, all right? If the consent form, however, is manipulative in any way, or form or fashion, or maybe strikes at somebody's property or liberty interests, that can be problematic. Okay? So due process. To establish violation of due process, an individual must first establish that he or she has some type of property or liberty interest that has been adversely affected. Organizations need to be aware that proper procedures when conducting a drug test. That could be the failure of an institution in the process of drug testing, could be how they conduct the test. They might have a very legitimate reason for it, but if they don't conduct the test properly, procedurally well, that could create problems for that place. All right? For professional sports, drug testing has to become a part of the collective bargaining agreement in which players and organizations come up with. So oftentimes this takes place in the form takes shape and form in that collective bargaining process. And really, drug testing is just a way to try to keep the essence of the sports intact, to minimize cheating and to create a true competitive spirit within the sport. All right, that's all for today. I hope you guys have a great afternoon, and thanks for your attentiveness to class.